Welcome to another explosive courtroom showdown. Today we're diving into a case that has everything: discovery disputes, accusations of police corruption, and a defense attorney who's absolutely not backing down. A drunk driving case that should have been straightforward has turned into a months-long battle over $86.92. Yes, you heard that right, less than $90 is holding up an entire criminal trial. But this isn't really about the money. It's about constitutional rights, prosecutorial obligations, and one defense attorney's relentless fight for discovery. Buckle up, because this courtroom clash is about to get heated.
Val Menace. I'm gonna
Val Menace. I keep messing up.
Val.
Too much for me.
Val. Menace. Okay. All right. And I do apologize for the delay today. Counsel.
Yes, Your Honor. Thomas Goosebank, Your Honor, appearing on behalf of the city of Wyandotte.
Okay, thank you. So today is the date scheduled for the adjourned pretrial. And counsel?
We're asking that the matter be set over so they provide discovery and/or I'll file another motion.
Well, okay, well, let's see. We held the motion hearing November 5th. And I ordered the prosecution to provide discovery within 21 days. So what happened?
If I may, Your Honor, the motion was held. Mr. Mays had produced the order. We approved it. Court entered the order, I believe, on December the 4th. We made contact with the records department for the city.
Now here's where things get interesting. The judge had already ordered the prosecution to hand over discovery within 21 days, that's 3 weeks, back on November 5th. This is a standard court order, not a suggestion. Discovery is the legal process where both sides exchange evidence before trial, and it's absolutely fundamental to a fair defense. Without it, a defense attorney is flying blind. They can't prepare properly, can't challenge evidence, and can't protect their client's constitutional rights. So when the judge asks what happened, you can hear the frustration in that simple question. It's been months since that order was issued, and we're still here arguing about basic discovery. The prosecution should have had this wrapped up before Thanksgiving, yet here we are well into the new year with nothing resolved. This delay isn't just inconvenient, it's potentially violating the defendant's right to a speedy trial and adequate defense preparation.
And the records are available. However, the issue is Mr. Mays is reluctant to provide the payment of $86.92, for the records. They are available immediately, but I spoke with the chief of police, who indicated that the procedure is that this is a charge that has been followed in the court's former process or continuing process, is the fact that retained counsel would pay for the discovery. So we are at an impasse, Your Honor. We need some direction because Mr. Mays does not want to provide the payment. We cannot secure the discovery to provide to him. Now, prior to that, we did provide Mr. Mays in September with a copy of the police report prior to there was going to be an implied consent hearing, which was resolved. And we also made contact on behalf with Mr. Mays, with Michigan State Police, who I believe provided Mr. Mays with a rather substantial blood test results. So the issue is the remaining materials that are in the police report.
Okay, so let me just clarify. So it's not the court's procedure for charging for discovery. That's something that the Wyandotte Police Department is charging.
Hold on, let's break down what the prosecutor just revealed. The discovery exists. It's ready. It's sitting in the police records department right now. But they won't hand it over unless defense attorney Mays pays $86.92. The prosecutor is essentially saying my hands are tied because of this fee. But here's the million-dollar question, or should I say the $86 question: do police departments have the legal authority to charge for discovery in criminal cases? The prosecutor claims it's standard procedure that retained defense attorneys always pay these fees. But notice what he's not providing: any legal citation, any court rule, any statute that authorizes this charge. He's relying entirely on that's how we've always done it. And that's precisely what defense attorney Mays is challenging. This isn't about being cheap or difficult. This is about a fundamental legal principle. If there's no statutory authority to charge these fees, then requiring payment could be an unconstitutional barrier to mounting an adequate defense.
For copies or, I don't know, digital stuff, I'm not sure. So, Mr. Mays, the discovery is available to pick up, correct?
Nope.
Hold
The prosecutor's not served me with discovery.
That wasn't my question.
I don't know what all conversations the prosecutors had with the police or anybody else, Judge, and I don't care. They can file a motion if they want, but all of what you just heard is a whole bunch of nonsense. The prosecutor has not served discovery, period. You ordered it. They've got a couple more weeks. I'm going to file another motion to dismiss.
So it sounds as though the prosecution has the discovery available, counsel, for you, but it sounds as though...
And there it is, defense attorney Mays just shut down the entire narrative. Notice his language, the prosecutor has not served me with discovery. Period. He's not playing games here. He's making a crucial legal distinction. It doesn't matter if the discovery exists somewhere in a police filing cabinet. It doesn't matter if it's technically available. What matters is service, the formal legal delivery of discovery from the prosecution to the defense. Under Michigan court rules, the burden is on the prosecutor to provide discovery, not on the defense attorney to go hunting for it and certainly not to pay for the privilege of receiving it. Mays is calling out what he sees as bureaucratic double talk. The prosecutor is trying to shift responsibility, claiming the police department's fee policy is creating the hold-up. But Mays isn't buying it. His position is crystal clear: you were ordered to serve discovery, you haven't served discovery, and I'm preparing to file another motion to dismiss if you don't comply. That's hardball litigation right there.
There's a cost issue.
Nope. Not as far as I'm concerned. They have not served discovery, period.
Your Honor, we would totally object to that comment. We have served Mr. Mays with discovery on 2 separate occasions. We have further advised Mr. Mays by both email and telephone conversation, which Mr. Mays has acknowledged in return messages back as to the questioning of the validity of the invoice. Your Honor, there's an invoice for $86.92. Discovery is available. I can't go to the police department and take it out of the police department. It has to be released. And the records department will not release it without payment of the fee. Now, Mr. Mays has cited in the past the court order. Now, not the court order, but excuse me, the court rule. Court rule is silent as it relates to the payment of this discovery. And so Mr. Mays can have all the discovery. We'll be happy to walk up the steps and provide, so long as Mr. Mays provides the payment. We've even suggested that to him. If he made direct payment, we would secure, because Mr. Mays was reluctant in the past to ascend to the second floor to get it from the police department. We would be happy to secure that and provide it. It's just that we need $86.90.
Now the prosecutor is making a fascinating legal argument that the court rule is silent on fees for discovery. In legal terms, when a rule is silent on something, that creates ambiguity. But here's the critical question: when a rule doesn't specifically authorize charging a fee, does that mean you can charge one, or does that mean you cannot? This is actually a fundamental principle of constitutional law. Generally, the government cannot impose fees or requirements that aren't specifically authorized by statute or court rule. The prosecutor is essentially arguing that silence equals permission. But defense attorney Mays is arguing the exact opposite, that silence means prohibition. If the Michigan court rules wanted defense attorneys to pay for discovery, they would have explicitly said so. They didn't. And there's a good reason for that. Requiring payment for constitutionally required discovery could create a two-tiered justice system where wealthy defendants get full discovery and poor defendants don't. That's a constitutional nightmare waiting to happen.
2 cents.
Your Honor, I've not been reluctant. This has already been briefed. I've already briefed it. They had no response to that, to the entire portion of that argument.
Of the monetary.
That's correct. I'm not reluctant. They have yet to provide any authority for it. I've indicated my motion
Authority for what?
for charging for discovery.
The court rule is silent as to that.
I've already briefed it, so it is not silent to it. I have already.
Counsel, just because you briefed it doesn't mean that the court rule is not silent as to cost. It leaves it in the court discretion as to cost.
No,
Yes, it
it
does.
is not up to the court's discretion.
Counsel,
There are procedures that they need to follow. They have not.
counsel, as to costs of discovery, it is up to, there is judicial discretion as it relates to cost of discovery. Now, there is a procedure for that. You're correct. There's a procedure for that. So, apparently if somebody's going to be filing a motion as to costs, I guess we'll set it for a court date. We'll set it for a motion hearing. But, absent.
Here we see the judge exercising judicial authority to clarify the law. She's making a critical ruling, there is judicial discretion regarding costs of discovery. This is significant because it means the decision about who pays for discovery isn't automatically governed by police department policy or prosecutorial preference, it's actually up to the judge to decide. The judge is acknowledging that while there are procedures to follow, ultimately the court has the power to determine whether fees are appropriate in this case. Notice how she's threading the needle here. She's not immediately siding with either attorney. She's saying yes, there are procedures for handling cost disputes, and yes, those procedures need to be followed. But she's also establishing that this is ultimately a judicial decision, not an administrative one. This is crucial because it means if someone wants to challenge the fee, they need to file a proper motion, present legal arguments, and let the court make a ruling. The prosecutor can't just unilaterally impose the fee, and defense attorney Mays can't just unilaterally refuse it. The judge is forcing both sides to litigate this properly.
That, apparently, you already have, you have discovery from the Michigan State Police, correct?
I have some.
And you also have some other discovery, correct?
Okay.
So just so that the record is clear, what discovery is it that you are still awaiting?
Judge, it's outlined in my motion.
Counsel,
They
I'm just
know.
asking for the record right now, what is it that you are requesting that you still do not have for discovery?
It's contained in my demand for discovery.
Counsel, I'm not reviewing that right now on the record through the written paper. I'm asking you to state it for the record, so we have it on the record, please.
Well, I can read it off. Let's see.
Yeah, please keep your hands on your pockets. Thank you.
Okay. In my appearance, we requested production of all police reports.
Counsel, what I'm asking for is what you do not have yet. So you said you have some discovery. So what discovery are you still requesting that you do not have?
I've got to go through it, Judge.
Well, but you also have received some discovery. So you said all the police reports. Did you receive any police reports?
I received a police report.
Okay.
Yeah, I'm looking at the police report that I've got. And again, as you stated earlier, I've got some materials from Michigan State Police.
Somehow.
But in terms of what I asked for, let me pull that document back up.
It's my people.
Yes. We asked for police reports, patrol car videos, 911 calls, and station house videos capturing my client's driving, detention, arrest, and
Counsel, I need you to slow down while I'm writing all this down. Okay, please.
It's all part of the
Police,
court file.
police reports,
Yeah.
patrol car videos,
911 calls, station house videos. Those were indicated to be exculpatory. And then We asked for exculpatory information. We asked, again, in discovery demands for police reports, written and recorded statements.
Wait, did you catch what defense attorney Mays just said? These materials were indicated to be exculpatory. That means someone, somewhere along the line, suggested that the patrol car videos, station house videos, or other materials might actually help the defense, not hurt it. This is absolutely massive. Exculpatory evidence is evidence that could prove the defendant's innocence or undermine the prosecution's case. Under the landmark Supreme Court case Brady v. Maryland, prosecutors have an absolute constitutional duty to disclose exculpatory evidence to the defense. It's not optional. It's not negotiable. And it doesn't matter if the defense attorney pays a fee or not, Brady material must be disclosed. So if there's even a hint that these videos might be exculpatory, the prosecution's failure to provide them isn't just a procedural violation, it's potentially a constitutional violation. This raises the stakes dramatically. We're no longer just talking about administrative fees and bureaucratic procedures. We're talking about a defendant's fundamental right to a fair trial.
Of whom?
By Ms. Volumenis, a co-defendant, an accomplice, even if that person is not a prospective witness at trial.
Is there a co-defendant in this case?
I don't know.
No, there is not, Your Honor.
Okay.
An affidavit, warrant, return, pertaining to any search or seizure.
Was there a search of blood in this matter?
I don't know.
Well, counsel, what do you mean you don't know? Was there a breath test taken or was there a...
You want me to read off my discovery demand? This is what's been
Counsel, I'm asking, was there a search warrant for blood?
Let's ask the prosecutor. Was there?
Counsel? Was there a breath test that was performed or was there a blood analysis that was performed?
I think it was blood, Judge, but don't hold me to that.
Well, I am. You're the defense attorney that's representing your client.
Oh, I'm sorry, Judge. I have an incomplete discovery file after months.
Counsel, you have the MSP reports, correct?
Would you like me to open those?
No, I'm asking, do you have those?
I have some materials from.
Okay, and so is that referencing that there was a blood test or a breath test?
No, it's gas chromatograms. So I guess that would be blood.
So you're asking for the search affidavit and search warrant for the blood test, correct? Or for
I'm asking
for the blood.
Any affidavit, warrant, or return pertaining to a search or seizure in connection with the case.
And I was asking to make sure that there was one that existed, potentially existed, or did not exist. Because if there was not a blood test, then that would not likely exist. So that was why I was asking that question, counsel.
Understood, Judge, but again, this is all covered in my last motion.
Counsel, I'm aware of what was covered in your last motion. I want to make sure, we're going through all of this so that we can have a clear understanding as to what discovery that you are stating you do not yet have.
Yeah.
And then I'm going to go on to my next set of questions.
Okay.
So that's why I'm asking.
All right. Then I asked.
As a retained defense attorney or any defense attorney, I would expect some of this stuff you would have knowledge of as to whether or not it's a blood or breath test. That is why I asked you.
Okay. So then I asked for any plea agreement, grant of immunity, or other agreement for testimony in connection with the case.
Does any of that exist?
No, it does not, Your Honor.
Okay, so that's not even necessary.
Well, it's necessary that they respond. So I'd ask the court not to make these sort of flippant decisions. This is for them to respond to. That's the whole point of giving them notice, months of notice, I might add.
So first of all, this court does not make any flippant statements. What this court is stating is that we're having an on-the-record discussion, so that right now you at least have the information that there aren't any such plea agreements. based upon what the prosecutor just stated.
Whoa, defense attorney Mays just accused the judge of making flippant decisions. That's a bold move, and not one most attorneys would risk. But look at what's happening beneath the surface. Mays is frustrated because the judge is essentially helping the prosecutor respond to discovery requests in real time, right there in court. When the judge asks, "Does that exist?" and the prosecutor says no, the judge says okay, so that's not necessary. But Mays is arguing that's not how discovery is supposed to work. The prosecution is supposed to provide written responses to discovery demands, not just verbally answer questions in court. Why does that matter? Because written responses create a record. They force the prosecutor to think carefully, research the issues, and commit to positions. Verbal responses in court can be vague, non-committal, or even forgotten later. The judge immediately pushes back, asserting her authority. This court does not make flippant statements. She's reminding Mays who's in charge, but she's also subtly acknowledging his point. There are procedures that need to be followed.
Well,
What's the next thing that you're
let's back up to exculpatory.
what's the next thing that you're requesting, counsel?
You asked if there was any exculpatory information. That was the first thing I read off.
Counsel, you're going through a police report. I'm writing all this down.
Exculpatory.
I'm going back. I'm going to go back and address some of this. I'm waiting for your list.
Okay. The names and addresses of all lay and expert witnesses whom the prosecuting attorney intends to call at trial.
Okay, next thing.
Any written or recorded statement by a lay witness whom the prosecuting attorney intends to call at trial, including all 911 recordings, videos, or other audio recordings.
So some of this sounds similar to the first list you gave me, the 911 calls. Okay.
The curriculum vitae of any expert the prosecutor may call at trial in either a report by the expert or a written description of the substance of the proposed testimony of the expert's opinion, and the underlying basis of that opinion. And in blood testing cases, this request specifically includes a request for the full litigation packet, including all sample prep, chain of custody, standards, controls, and data pertaining to the underlying GCFID, GCMS, and or LCMS-MS documents pertaining to blood analysis that provides a basis for the expert's opinion, as well as notes, printouts, and copies of the complete run, identifying the specific device used and employed and its maintenance records.
Okay. Is that the extent of your list?
No.
Your request.
Continues. Any criminal record that the prosecuting attorney intends to use at trial to impeach a witness, any document, photograph, or other paper that the prosecuting attorney intends to introduce at trial, including all video and or audio recordings, including body cams, in-car cameras, and booking room video, and a description and an opportunity to inspect any tangible physical evidence that the prosecuting attorney intends to introduce at trial, including all expert witness materials that might be introduced pursuant to MRE 703, and in all blood testing cases, release of the second sealed blood sample to Ms. Volumelis independent laboratory for independent testing by a qualified forensic laboratory. And that was requested, it was mandatory within 21 days, dated, August, 4 months ago. Before my motion was filed.
So out of that list of items, counsel, which pieces of discovery have you received?
I have a police report.
Dated when?
Let's see. Police report. That police report was printed on September 4, 2025.
What's the date of the report?
That's, the date of the report. There's a status date of June 30th, 2025. I can't quite tell. And it is 7 pages long.
Okay, but you have the report. So on the first page, I believe somewhere at the top, there's a date of incident or something.
It's got the incident date, yeah, but that's not the date that the report was necessarily drafted. And
Okay, and what else have you received?
let's see. Oops, I can't open this last one. It's not opening on my thing, but approximately 2 months ago, I got some materials from Michigan State Police. And that's it.
Okay, and what are those materials, counsel?
Judge, I can't go through all that. Like I said, it's not open on my phone.
Do you have a summary of a description of what it is?
No.
Are they reports? Are they is it analysis?
Some records from Michigan State Police,
Okay,
but I can't open it to give you a comprehensive list because it's not open on my phone.
okay. So, Mr. Kuzniak, you hear the discovery that Mr. Mays has indicated that he's still requesting. And are those items included in that in the packet that you're indicating is available upon the payment of $86.92?
Your Honor, I believe the vast majority of those items are included in that packet, including the videos and the statements that Mr. Mays has indicated. You know, it was at 9525 that we provided him with the police report that we had secured. And it was on October 17th of 25 where we did confirm with Michigan State Police that they had forwarded the materials, and the staff of the Michigan State Police indicated they knew exactly what Mr. Mays was requesting, so they would be sending down the package, you know, that would be from a discovery perspective. So, Your Honor, if we could secure the records from the records department, we would be more than happy to deliver those to Mr. Mays, and I do believe many of these items that he has addressed would be included.
Okay, well, prosecution says that they have the discovery ready for the defense, and you submitted an invoice to Mr. Mays?
We sent an invoice to Mr. Mays. Mr. Mays acknowledged the invoice. He sent us an email indicating under what authority did we have to send him an invoice. We weren't sending him the invoice to reimburse our office. We were sending him the invoice to pay for the record so that we could secure them.
Like I said, in my original motion, Judge, garden variety drunk driving cases have become a lucrative source of financing for local police departments. And that ended when the Michigan Supreme Court promulgated the discovery rules and said, no more. This is no longer a profit generating device. The prosecution had no response to that. And yet they turned around, they provided a proposed order that would have, again, you know, hey, Mays, pay this bill so we can make a little bit of extra money off of our DUI cases. And I said, no, I filed a motion. They don't respond.
Now we're getting to the heart of defense attorney Mays' argument, and it's explosive. He's alleging that drunk driving cases have historically been used as revenue generators for police departments. Think about that for a moment. If police departments were charging fees for every piece of discovery in every DUI case, and they handle hundreds or thousands of these cases per year, that could add up to significant revenue. Mays is arguing that the Michigan Supreme Court shut this down when they created the modern discovery rules that were designed to ensure fair trials, not to create profit centers. And here's his most damning point: the prosecution had no response to that. When an attorney makes a serious legal argument in their motion and the other side doesn't respond to it, that's often because they don't have a good response. Silence can be very telling in legal proceedings. The prosecutor never provided legal authority for the fees, never explained how they square with the court rules, never addressed the constitutional implications. They just kept insisting this is how we've always done it.
To that allegation, the court heard the arguments on it, and like the prosecutor's admitting now, I said, by what authority are you charging for this? No response. No response. So, with no authority for that, and the court rule and the order existing, I mean, I'm going to be moving to dismiss yet again. If the police don't want to provide this to the prosecutor, then I guess That's just a gosh darn shame. That all said, though, I wanted to refocus the court's energy back at that exculpatory evidence that I pointed out earlier, because the court didn't ask any questions about it. If I understand the prosecutor correctly, there are videos in this case and other reports, and the prosecutors reviewed none of these materials. His hands are tied, he says to this court, because he can't provide it. He has no authority to. He has no authority to serve discovery consistent with the Michigan court rules. And he hasn't reviewed any of those materials because he doesn't have them. He's waiting for Mays to pay the requested fees, for which there's no authority. So that means that the prosecutor does not know if there are exculpatory materials in this case, because he has not done his due diligence under the Michigan Rules of Professional Conduct 3.8, which I cited in my initial pleadings months ago, that requires a prosecutor under Brady to go out of their way to determine whether or not there are exculpatory Brady materials in a criminal case. Here we are, 4 or 6 months into it, after I filed a motion, after I've got an order compelling discovery, and the prosecutor has the audacity to tell Your Honor, well, Mays hasn't paid it, so I haven't reviewed it. So the prosecutor has no idea if there are exculpatory materials. For all that we know, the officer that arrested my client might be in prison right now because of taking public bribes and blackmailing people.
Well,
and
okay, now, hold on. No, stop. First of all, there is absolutely no basis for that statement, Mr. Mays. I'm not going to allow frivolous statements like that to be made where there's unfounded anything. Okay,
This is where Attorney Mays drops an absolute bomb. He's not just complaining about discovery delays anymore, he's accusing the prosecutor of potentially violating Brady versus Maryland, one of the most fundamental constitutional protections in criminal law. Here's what makes this so serious: prosecutors have an affirmative duty to seek out and disclose exculpatory evidence. They can't just wait for it to fall in their lap. They have to actively investigate whether such evidence exists. But according to Mays, the prosecutor in this case hasn't even reviewed the materials that are sitting in the police records department. How can the prosecutor fulfill their Brady obligations if they haven't looked at the evidence? They can't. And then Mays makes that inflammatory statement about the arresting officer potentially being in prison for corruption. The judge immediately shuts that down as unfounded speculation. But look past the provocative language to the underlying legal point: if the prosecutor hasn't reviewed the materials, they literally don't know what's in them. There could be evidence of police misconduct, evidence undermining the arrest, evidence supporting the defendant, and the prosecutor has no idea because they're waiting for an $86 check.
It's not happening. There has been statements made that the materials are ready. There has been communication to Mr. Mays that that there is an invoice so he can have the materials. He doesn't want to pay, and there is a motion filed. Then I guess we'll have to handle that as we handle it.
January 7th? For an adjourned date?
I will give the adjourned date in just a moment, counsel.
That was a question.
No, I think that we have a full January.
The judge is clearly frustrated with both sides at this point. She shuts down Attorney Mays' speculation about police corruption, calling it frivolous and unfounded. But notice what she does next: she doesn't rule in favor of the prosecution either. She essentially summarizes the stalemate: the materials exist, there's an invoice, the defense won't pay, and a motion has been filed. Her response? We'll have to handle that as we handle it. That's judicial speak for this needs to be properly litigated. She's not making a snap judgment about who's right or wrong on the fee issue. She's requiring the parties to follow proper procedures, file motions, present legal arguments, let the court make a reasoned decision. This is actually good judging. Rather than making an off-the-cuff ruling that could be appealed, she's ensuring there's a proper record and adequate briefing on what turns out to be a complex constitutional and procedural question. The case is getting adjourned yet again, which means more delay for the defendant, but at least there will be a proper hearing on the discovery dispute.
January 7th in the afternoon. Does January 14th work for us, Ally?
I'll be in Austin, Texas at a forensic science seminar,
When are you returning?
Saturday.
Okay, does January 21st work for us?
21st? Yes, it does.
Does it work for us, Ally?
Yes, at 1:30.
1:30. Got it. Sorry, I'm losing my voice, Judge. All this advocacy.
Or other scenarios. Your Honor, I would only state that Mr. Mays has made some very concerning comments with regard to the Office of the Prosecutor, and I'm going to want to object to those comments because we have complied with his request. We've had more than 10 communications, both either email or phone, to attempt to resolve this matter. And Mr. Mays loves to go out on his rants to try to bring these issues before the court, but that is not true, and I take objection to his comments with regard to our office.
Judge, they can easily eliminate all of my rants.
Counsel, we're done. We're done. We're done.
Yep.
Mr. Kuzmiak wanted to place his objection on the record, and we'll see everybody back on the 20th.
So here's what just happened in this absolutely wild courtroom showdown. A routine drunk driving case has turned into a months-long constitutional battle over $86.92. Defense attorney Mays argues that charging for discovery violates Michigan court rules and creates an unconstitutional barrier to adequate defense. The prosecution claims they're just following standard police department procedures. The judge has indicated she has discretion on cost issues but wants proper motions filed to resolve this dispute. At its core, this case raises fundamental questions about access to justice. Can government agencies charge fees for constitutionally required discovery? Does requiring payment create a two-tiered system favoring wealthy defendants? And most critically, can a prosecutor fulfill their Brady obligations to disclose exculpatory evidence while the evidence sits unreviewed because of a fee dispute? The case has been adjourned until January 21st, which means the defendant's trial is delayed yet again. The underlying drunk driving charge hasn't even been addressed. We're still fighting about whether the defense gets to see the evidence. This is what happens when bureaucratic procedures collide with constitutional rights, and it's a battle being fought in courtrooms across America every single day. If you found this case as shocking as we did, make sure to hit that like button and share your thoughts in the comments. Do you think defense attorneys should have to pay for discovery, or is that an unconstitutional burden? Should prosecutors be required to review evidence before demanding payment? And what about those potentially exculpatory videos? Should they be disclosed immediately regardless of any fee dispute? Drop your opinions below, and don't forget to subscribe for more jaw-dropping courtroom breakdowns where we analyze the legal battles that really matter. We'll see you in the next one.